So good afternoon, everyone. Thanks for joining us. This Financial Poise webinar is titled Overview of General Corporate Law Compliance for Corporate, and it's part of the Corporate and Regulatory Series, Corporate and Regulatory Compliance Bootcamp 2024. Slide 7 of the PowerPoint will give a summary of the episode. Slide 8 summarizes the series. Speaking of the slides, we don't step through the slides for the PowerPoint. You're not going to have to listen to us read slides. On some of our presentations, the slides are important because they'll catalog different data, maybe even some of the penalties and recoveries in certain areas of compliance. But you won't have us referring to them during this. This is more of a conversation between myself and the panelists and each other. And but keep the PowerPoint handy. You'll definitely have it as a great resource afterwards. It's a good summary. We try to put in updates every year, but it's a very good summary of the area. I've got two wonderful panelists today. Number one, I've got Alyssa Habert with the Delaware Counsel Group, and I also have Odra Nawazi from Faegre Drinker. And I'm Raphael Zahardin. I'm with Lewis Brisbois Bisgard Smith. You don't need to hear much about us. If you really like us, you can go ahead and read about us on slides 52 to 55. And again, this webinar is a production of Financial Poise. You'll find more about Financial Poise on slide 58. If you're attending the live premiere of the webinar, you can submit questions using the web portal. We rarely get a chance to. This is such a short hour. It sounds funny, but it's one of the shortest hours I usually experience, and but it is something we do follow up on. We do contact folks, and if you are watching this on demand, and if you have any questions after the webinar or during the webinar, if we don't get to you, please email info@financialpoise.com. It does come back to us, and we do follow up. This PowerPoint and the conversation are meant for general education purposes. They are not a replacement for legal advice, so please do not take it for that. One last note, I want to thank our sponsors. You can find Mood, Type to Learn, and Max Asset over on slides 3 and 4. And then with that, let's go ahead and start the substantive portion of the presentation. So we're going to cover a bunch of statutory requirements under state law with a focus on Delaware, but we'll mention some other states where there's a deviation. And we'll do that for corporations, alternative entities, and other exempt entities. And why don't we start off just talking about, how heavy a burden are the compliance requirements for state corporations? And I'll start off by asking Alyssa that.
The misnomer is, unlike jurisdictions abroad in Europe throughout, where there's a central registry and such, where a good deal of information is required to be posted, little is publicly available unless you're a public company and listed on an exchange, and therefore lots of information and financial reports are available. But if you're a private company, really what's necessary with the state is merely a very brief annual report that's filed and a payment of an annual franchise tax, which is based upon the number of shares or the asset par value of your shares. And that's it. The real one comes that you have to internally maintain your records in accordance with the Delaware statutes and the bylaws of your entity. And this is where I think there's a greater need for attention, because there needs to be a record of the board acting and supervising the company. And there has to be a record that the compliance with the supervision or the implementation of the supervision has been done properly by the delegatees, typically the officers in the corporation. And the same is true with alternative entities.
Yeah, and I think the only place where there is a little bit more, and it is a decision state by state. Delaware basically for exempt entities has a you put a quick report in every year. Really, it's attaching the report you send in to the IRS, and they let the IRS handle that because they figure that apparatus is enough for regulation. But there's some states like New York that if you solicit anyone for a nonprofit donation, you have to register within the New York State Attorney General's office. There's a charity bureau, and I think that, like a lot of other regulation on solicitation of, on lending, etc., that New York has a more stringent because of historical criminal activity and fraud that was perpetrated on its citizens there, whereas it's just a little bit different of a choice here in Delaware.
Sure.
And I've never seen anyone say that Delaware is a haven for charitable fraud. I mean, it's just not. And we've had the different crackdowns on information after the Panama Papers and things of that nature, but and now we have a federal law, the Corporate Transparency Act.
Right.
It's supposed to just give a little bit more information into things, but otherwise it is pretty light. But you do, as you said, you have to have your ducks in a row in case there's a reason for a regulator, or you get a litigation hold letter, and you better have things. And we'll talk more about how that affects the record keeping as well.
Or forget about it's not even in the dispute context. A shareholder under certain circumstances has the right to access records, and you need to have them. Well,
look, I always books and records actions, which I know they're not a favorite of anybody's except for the plaintiff's bar, right? Because that's our version of pre-litigation discovery that's only available in certain states on the state law level, and we don't have that otherwise in our statutes in the Delaware Code. But that's essentially what that's turned into, and not necessarily to file in Delaware. Usually, it's to get information to go file it in a place that's friendlier to the plaintiff's bar. Odorok, can you walk us through the requirements by the type of entities, just to give a flavor for what each type of entity has to pay and do? And just as an aside, everything's due March 1st usually in Delaware, so it's pretty consistent across the board. But go ahead.
Yeah, sure. So corporations, alternative entities, and non-stock nonprofits have varying requirements. Corporations have the highest franchise tax, and that minimum tax is $175 for corporations using the authorized shares method, and a minimum of $400 for corporations using the assumed par value capital method. And all corporations using either method will have a minimum tax of about $200,000 unless it has been identified as a large corporate filer. In that situation, the corporation's tax will be around $250,000. Alternative entities such as limited partnerships, limited liability companies, and general partnerships pay around $300 in franchise tax annually. The penalty for non-payment or late payment is $200, and interest on that penalty runs at about 1.5% per month. Exempt entities are basically those that qualify under the tax code as a 501c entity. Even if the corporation does not get IRS tax exempt status, but is still organized as a non-stock nonprofit, or the franchise tax is zero, those corporations are still exempt. All non-stock for-profit entities that don't comply with the exempt corporation requirements will be required to pay a franchise tax of $175. Delaware entities also pay an annual report filing fee. Non-exempt domestic corporations pay an annual filing fee of $50. Foreign corporations pay an annual report filing fee of $125. The fee for filing an annual report for an exempt entity is $25, and the fee for filing an annual report for a limited liability partnership or a limited liability limited partnership is $200 per partner. In order to file as an exempt corporation, an entity must meet the requirements of Title 8, 391J as follows. The term exempt corporation shall be defined as any corporation organized under this chapter that is not authorized to issue capital and that is exempt from taxation under 501c, qualifies as a civic organization, qualifies as a charitable fraternal organization, is listed in 8106A of Title 9, is organized primarily or exclusively for religious or charitable purposes, or is organized as a not-for-profit and no part of its net earnings inure to the benefit of any individual member.
All right, great. Melissa, how do the requirements for the annual report vary between the different types of entities?
It's nominal information required for any of them. I don't know how much more to elaborate there. Typically in a corporate structure, you're to identify officers and directors of the company. And of course, the corporate address. And in the alternative entities, it's not much different. They want to know, the management of the company. I think now what people have to pay more attention to is, as you mentioned, the Corporate Transparency Act, and that's a federal, not a state filing. So that takes a bit more care. And I think it's beyond for what we're supposed to talk about today. But especially if you have an alternative entity or you have an entity that's part of a family of structures, there are going to be some issues that are going to have to be carefully considered. But the annual information that's filed with the state is of little consequence, in my opinion.
And are there separate requirements for Delaware statutory trusts?
No, there's not. There's nothing different there. The difference there is not necessarily with respect to compliance with filings with the state. It's just that in order to create the statutory trust, you have to have a Delaware trustee, meaning an entity that has trust powers under license at the state of Delaware serve as your Delaware trustee. And that's typically going to be your bank and trust companies are the ones that have that power. And they have to be a party to the statutory trust in order for it to be recognized validly under Delaware law. So again, that's not a filing with the state, but in order to have one in the state, you've got to maintain that relationship.
Okay, so generally speaking, we don't have an onerous filing, regime here in Delaware.
No.
And we have to make sure we do things the right way. Corporate meetings are a good example of that. Odra, can you walk us through corporate meetings and the requirements, the types of meetings, just and then maybe also where do we find those requirements afterwards? But give us an overview and then tell us where do we look for these rules and regulations, or maybe even kind of internal contractual provisions that deal with corporate meetings.
Sure. Well, before I talk about the annual stockholder meeting, I think it's important to kind of zoom out and recognize that the stockholder meeting is the mechanism that stockholders use to exercise their voting franchise, right? That's how they exercise their dominion or control over the management folks, the board of directors that they selected to be their fiduciaries. So, it's really the opportunity for them to get involved in the direction of the company by voting on certain corporate acts or electing directors. And so for most corporations, there has to be an annual meeting for stockholders to discharge that right within 13 months of the prior annual meeting, or within 30 days of the date designated in the corporation's bylaws. And if that doesn't happen, any stockholder or director can petition in Delaware, the Court of Chancery, to direct that a meeting be held. And I think it's important to recognize that annual meetings obviously are important because of the subject matter of those meetings, but it's also like the right of stockholders to discharge their responsibilities or their voting rights with the company. And that right is so important that even bankruptcy cannot justify not holding an annual meeting. So annual meetings for public and private companies can be distinguished. For example, private companies may act by unanimous written consent, and alternative entities are not mandated under Delaware law to hold annual meetings, whereas public companies, are mandated to hold annual meetings. And quite frankly, if they don't, there will be some stockholder activist that gets involved to kind of force an annual meeting.
Awesome. And did we talk about where we find the requirements?
No, so you can find the requirements in the state law of where the particular entity is incorporated. Maybe there's a corporate charter, organizational documents, bylaws that have a mechanism where they give the instructions for calling an annual meeting. And most states require that an annual meeting notice has the date, the time, the place of the meeting. And typically the way that you notice that is set in the bylaws or operating agreements or partnership agreement. Federal law doesn't focus on the annual meeting itself, but really focuses on the communications with stockholders, particularly proxies, and something like the stock exchange rules. And that's really meant to ensure that stockholders not only are aware of the annual meeting and can attend, but are also aware of the issues that need to be dispatched of at the annual meeting and have enough time to kind of educate themselves on the issues so that they can vote.
Okay. And Alyssa, what happens if you don't hold an annual meeting?
What happens is a shareholder, under Delaware law, if a meeting hasn't been held for 13 months, a shareholder may bring an action and in this Court of Chancery and request that that the court order a meeting to be held. And the most important thing for the annual meeting, as Odora said, you need to have an opportunity for the shareholders to weigh in and get information, but probably the most important thing is they get to elect the directors of the corporation. And that's the most important way in which they get to influence management in the direction of the corporation. And they need to have that opportunity. But again, as Odora also noted, you can do it by written consent if all the directors are up for re-election. And so there's really no reason not to be able to give the shareholders the opportunity to weigh in. And
Right.
that consent will work, if you can get everyone on board.
Yeah, I guess the requirement, I think, is usually unanimous, right, to do stuff by written consent.
Correct.
Yeah, so.
Well, with respect to a board of directors, it is. The shareholders can act by written consent by majority vote, but then you have to give notice to those that did weigh in of the act.
Right, okay, yeah. That's a very good point. Odora, what other kind of meetings do we have outside of the annual meeting?
You have regular board meetings or special meetings. And depending on what the bylaws or the operating agreements of a particular entity say, these can be called by directors, officers, or even stockholders. And these meetings can be in person or electronically. There are even alternatives to meetings, as was noted before, which are called written consents. And some companies allow them, and sometimes they have to be unanimous, as you all noted, with the election or removal of directors, or in some certain instances, they can just be by majority vote. Now, outside of the context of an annual meeting, there aren't really a ton of requirements that any state law, particularly Delaware, sets for these board meetings or special meetings. The board of directors can designate committees of the board that can meet and exercise all powers of the board delegated for that particular committee. So if you think of in the context of an audit committee or a compensation committee, and even in some instances, you can have a subcommittee where that subcommittee has all or some of the powers of the committee itself. Under the DGCL, one of the officers of the company, usually known as the board secretary, will have to record the proceedings of the meeting and put those recordings in a corporate book or corporate records. In other words, what I'm saying is that there's a legal requirement for someone to take meeting minutes from any board or committee meeting. And then those meeting minutes are going to be part of the corporation's books and records. And whether a stockholder or director action is the result of a formal meeting or from some kind of written resolution, that action has to be more memorialized in the meeting minutes, because, someone looking backwards, the only evidence they'll have of that thing occurring is that it's reflected in the meeting minutes and it's in the corporate records. And then, as it relates to auditors will typically begin their review of corporate records with the minute book. And so if the minute book is up to date and it contains regular records of the board and, shareholder activity, the auditor likely will be favorably impressed, and that good impression may help in the entire audit process. But unfortunately, and this comes up a lot with my clients, and I'm sure other folks in the corporate governance arena, they're always asking whether or not there are specific rules for recording meeting minutes and or the level of detail required. And there are some people who think that you should have very little information, and there are some people who think you should almost be a stenographer and take down every word. And I, at least in my view, it's not a science, it's more of an art. And so really the detail should be somewhere in the middle of that.
Go ahead.
I was just going to say, I couldn't agree more that it's an art, not a science, and it really depends upon what the corporation is doing, what the status of it is, the relationship with its shareholders. We just had a matter where I'm advising a board on its fiduciary duties in connection with the conflict transaction. Well, there you want details of all the efforts taken and details of the consideration made, etc. Other situations that may be the subject, for example, of, an executive session or something where, there's confidential information that you don't want to make a record of. So it really depends upon what you're dealing with.
Yeah, and look, protecting confidences is a fiduciary obligation. So it's not a, I think that when being most conservative, I've tried to tell people that the rule of thumb I use is you need to show that you've met the requirements for a meeting, and you need to show every single time. You need to show when there's action taken and when there's discussion, but you don't have to give such details on discussion that you're giving a roadmap for somebody to sue you later. So it's but you're right, it is more of an art. Oda, we talked a little bit about consents. Have those been weaponized in some way? Are they used differently in public versus closely held corporations?
Yes, I mean they are weaponized, or at least there's an argument that they can be weaponized in order to either make it impossible for stockholders to move to vote on a transaction through written consent or to approve transactions through written consent. And one way that that's done is by requiring a unanimous written consent for almost everything, right? And so if you do that, then it's probably unlikely that anything that requires a stockholder vote will be passed, because it's virtually impossible to get unanimous written consent for stockholders. Charters and bylaws of a company typically will set the frequency of regular board meetings and special meetings, and who can call those meetings. And then in non-public companies, written consent are seen as a means of convenience for stockholders, so that stockholders don't have to be in a particular physical place or even virtual place, and they can just make sure they return their signature, their approval for the consent at a particular time. Written consents are generally valid unless the certificate of incorporation prohibits the written consent or requires a unanimous agreement. And written consent can't be restricted by a bylaw provision. Any restriction on written consents must be in a charter, and must be approved by stockholders, because in most jurisdictions, but Delaware in particular, there is a scrutiny on anything that limits the stockholder franchise, right? The right to vote. And so that for that reason, if there's going to be a requirement that a written consent for stockholder actions must be unanimous, stockholders must approve that in the charter. In public companies, written consents have been pushed by stockholder activists as a means to give more power to stockholders so they can hold special meetings or act outside of annual meetings. Section 213 of the DGCL sets the record date of meetings or written consents, and Section 228 generally governs the use of written consents under Delaware law. And as was mentioned earlier, Section 141K, it's under that provision that a majority of stockholders can vote to remove a director from the board of directors through written consent. And as I noted before, consents are now a big deal with stockholder activists. There's according to Harvard Law School Forum, I think in 2010, only about 28% of Fortune 500 and 31% of public companies permitted stockholders to act by less than a unanimous written consent. But I think those numbers may be increasing given the interest in limiting stockholder activism.
So,
And I would argue, or to say that, and in all the cases, even if a written consent is authorized, many transactions under the statute require the board to initiate the action. So even if the right exists, those shareholders have to convince the board to trigger the
That's
action.
right.
well, let's talk a little offense and defense. I have tried and hesitated to use sports analogies in my
Yes, because then you're going to lose me real fast.
But-
Yeah.
but you know the difference between basic offense and defense.
Yes.
So let's talk about there's no real statutory guidelines how to conduct a meeting. So you're as we've kind of, the theme has been, well, but you still have to do things the right way. So what is it that you can do to make sure that you are proactive and set up best practices? What are some pointers for conducting a meeting?
Are you talking in the corporate structure?
Yeah. So
Or
if you're
not-
handling an annual meeting,
Well,
is
I
there?
think-
Go ahead.
I'm sorry, I keep losing there. I think that what's important with conducting a meeting is you need to know and plan in advance when you give notice to the shareholders of what issues you're going to address, what presentations are going to be given, and certainly give information about the directors that are up for election. When you go to the meeting, having had that agenda distributed, follow the agenda and have in mind issues that you think the shareholders may raise that you need to be prepared to answer, and how you answer that effectively, truthfully, and yet restrain yourself from disclosing any information that should not be shared in a public context. That's the most important thing. And if you want the shareholders to take action, that you've provided them with the information, there's a record that you've provided them with the information necessary for them to be informed, so that if they vote in favor of something or against something, they're doing so on an informed basis.
And how about, are there rules of the road for how you conduct the meeting? I mean, are there kind of procedural guidelines for people? I mean,
like Robert's Rules of Order,
yeah,
or something like that? No,
yeah,
they're followed. Robert's rules, some of the principles are followed, but they're not mandated.
right.
The idea is that everyone should be able to hear each other. Okay, so if you're holding it somewhat virtually or in person as well, people should be able to clearly hear things. Information should be clear and distributed. And if you need people to think about things, and you're in a private context, unlike in the public context where there's filings and distribution of things in advance of the meeting required, some of that same advice follows here. Make sure the shareholders are prepared to and have good information that they can ask questions about, to evidence that you are working with them, informing with them, but also getting a valid vote from them.
So the attack on a meeting afterwards usually comes in the form of whether or not it was a legitimate meeting, and they'll say that if it wasn't a legitimate meeting, you didn't follow the noticing or other requirements.
You didn't have quorum. You didn't get the right vote. Exactly.
That's right. Then the whatever happened at the meeting wasn't authorized properly, which is what the way you attack it. How do you prevent that? I mean, you mentioned quorum. Are there other things that you want to do to make sure you have those records ready, because they're going to be your best line of defense?
Well, the first thing is, number one, make sure you get the information out in advance of the meeting, make sure people are noticed properly, look at the statute, look at your bylaws as to what, if any, specific requirements there are, and make sure you carefully have somebody helping you count the number of persons present before the CEO or president or the chair of the meeting has the necessary quorum. And again, your bylaws have a specific number. If not, you're relegated to what the statute requires. Make sure those things are in place and have help convey, calculating those. Also, if you're allowing people to act by proxy, get your proxies counted. In other words, don't just rush into the beginning of the meeting. Make sure your ducks are in order and that you have the proper representation of shareholders before you begin. And with respect for issues that are up for discussion, clearly, if you've asked the shareholders or want the shareholders to take action on something, you would have available all the information you want to share with them, having distributed it earlier or going to share it for the first time during the meeting, and make sure you're prepared with the right people there to answer any questions that shareholders have about the proposed course of action, and that you are giving them all the details. That all has to be prepared in advance.
If I could jump in too, I think the only other thing I'd add there is to make sure that the transactions or the corporate acts being voted on require stockholder approval, or what is required to consummate those transactions. I've unfortunately been in some situations where things were put for stockholder vote that weren't necessary, or things weren't put up for stockholder vote when it was necessary. So, to the point that was just made about planning things, I think you need to go through the bylaws or operating agreements and ensure that the corporate acts or transactions being brought up at an annual meeting actually require stockholder approval.
Can you give some color to the issues of virtual meetings. We've talked about the fact you can have them. Are they really different or hybrid meetings from what we just discussed?
No, they're not. I mean, I think the biggest takeaway, and I think the point's been made a couple times already, is if you're going to host a virtual meeting, there needs to be a lot of intentionality on the front end to make sure that stockholders can be engaged in the same way that they would be engaged in person at an annual meeting. Meaning that if things are being discussed, they can hear the discussions. If there's a need for a vote, the vote can be done virtually and uh, their viewpoints be accounted for as opposed to only those of whoever might be in the room. And so those are the really important pieces. I think so, just like you would for a in-person meeting, given notice of where the meeting is going to be and what time and how it's going to be conducted, you have to do the same for a virtual meeting and ensure that stockholders in enough in advance know how to log into the virtual meeting, know how to vote if they need to, know how to ask questions. And so there really aren't significant differences. It's just a convenience. And I think that during COVID, for example, in Delaware, I think the the legislator realized that virtual meetings could be a real help for corporate governance instead of having everyone convene in one place. Under Section 211A, now virtual meetings are allowed in Delaware. And so, like I said before, you have to consider things like, do we have adequate technology to reach everyone who wants to participate? Do we have a plan in place to give equal opportunities to both in-person and online participants? Um, is the virtual meeting actually in the best interest of the majority of stockholders, right? I think that's a crucial question because if there are really important, nuanced issues to be discussed or perhaps transactions to be voted on, I mean, I could see a serious argument for that annual meeting being held in person so that there can be kind of a more free exchange of information. But if you're just voting a uncontested slate of directors or approving transactions that are essentially unopposed, yeah, that stuff can be done virtually. But you have to put some thought into what actually is being discussed at the annual meeting.
I would make one other suggestion and to supplement what Odera said is that, sometimes in companies, the principal shareholders have a separate agreement amongst themselves with respect to how they're going to vote. And the company, to the extent they can, needs to be aware of what is in those agreements to see whether or not to contemplate what they may be faced with in terms of how blocks of shareholders may vote or not vote, or provide a challenge to getting through what the company is trying to do. And that's something else to be prepared for.
Yeah, I think that's absolutely right. Um, I would also add that if there's controversial management or stockholder proposals that need to be considered at the meeting, I think that those are the types of issues that should be handled or probably best handled in person. Um, and then there's been some SEC guidance on stockholder meetings after COVID-19, particularly given that a lot of stockholder meetings are now virtual. And so the new guidance discusses delays in printing and mailing of proxy materials to ensure that stockholders have ample time to prepare for the meetings and educate themselves. And then there's a clarification from the SEC on the position of the Division of Investment Management. And so that guidance applies to meetings by investment companies in connections with business combinations and other transactions described in a registration statement form N14, except that in lieu of the announcement of the change being filed as additional definitive soliciting material, the SEC would expect the announcement to be filed as a prospectus supplement under Rule 49. And then
But this
there's
is all if you're a reporting company. right?
That's correct. That's correct. And there's also some guidance for public company stockholder meetings. Changes in date and time and location,
Sure.
need to be, uh, timely
Mhm.
communicated to the stockholders. Maybe there's going to be a press release announcing a change, or um, there's an announcement in a filing with the SEC, or just other steps that are reasonable and necessary are taken to make sure that proxy service providers or relevant market participants are aware of any changes.
And I think I don't want to go too off course, Raphael, unless you wish to go there, is that we throw all of this out the window when you're dealing with alternative entities.
No, I
Especially,
mean, we should discuss that. I mean, in other words, you can contract yourself out of everything here within
exactly.
reason, right?
And all the things that we're talking about, what's information is confidential, what's not, whether or not the meeting has to be held, under what circumstances investors or parties to an LLC or a limited partnership are entitled to get information. Most of this is all negotiated in a private entity or in funds, big funds where you have investors making investments of, 100 million plus. They're negotiating these terms. So the agreements, the details of the agreement are going to govern just how much prep you need, what can and can't be done without the involvement of the other parties to your entity. It could be anything. There are no hard and fast rules as to what you should expect or prepare for, except that you better know what your agreements say. And what complicates things is that investors making substantial investments will often get letter agreements in addition to the constitutional document of the LLC or the partnership the people are investing in, that purportedly provide them with different rights than those set forth in the constitutional documents. And the truth of the matter is, first you have to assume that you're allowed to do what you said you would do in those letters before you do it. And second of all, what rights you've given different investors is going to impact what kind of votes required or what kind of participation you're going to dictate. So be very careful when you're outside of the corporate context. You've got a lot more homework to do.
Right. Right. What goes in the final meeting minutes? So we planned everything, we thought about it, we pulled it all together, and now you've been handed this as your corporate counsel and vice president and secretary of the corporation. And you've been tasked with making sure that you get out the final meeting minutes to be approved at the next meeting or however you handle it. We talked about before, having a transcript is what some people do, or they throw it on Otter AI or some other, not to give them, we're not being sponsored by them, but that's a fairly typical thing I've seen people do. And are there problems with that? What should the final meeting minutes, if I had to have a little checklist of things, I need a takeaway, what do I do, and why not just have a transcript? I know we covered a little bit of this before, but let's bring it to a finer point for people.
Transcript, or you then, if 5 years later you're going to go back to look at it, are parties going to remember all the details you put in those minutes?
Yeah.
I think that's hard to reflect everybody's recall. I think the most important thing to record at a minimum is what was presented, what kind of discussion there was in general terms, subject to, really touchy situations, but in general, what was discussed and what was the result after the vote was called. To have all the detail that this shareholder asked this question or that shareholder asked another question, I dare say I don't know how that's going to help you when you go to look at it years after, is somebody going to even remember what they said during the meeting? I think you just want to know that an issue was addressed, was considered, information was provided, questions were answered, and then there was a result that was properly calculated based upon the persons there in the room, and or virtually participating, and that it's a valid action.
Yeah, and I think the valid action piece of it is one of the pieces of advice that I give to people that ask this question. And, you know, if you're exercising your duty of care, for example, which is fiduciary obligation, you know, you make sure that if you had a report from a committee, or you had counsel there, or an accounting firm or valuation expert, that you note that, because that only supports you are relying
Of
on
course.
somebody's information. And a lot of times people forget that. They're like, well, wait a second, that's too much detail. I was like, no, that's the detail you need. You can get rid of the transcript, but if you have someone in there and they give you legal advice, or there's a valuation expert or whatever, that's what you need to sit there and say. Or, you know, committees are set up to be independent for a reason, because they don't have someone who they demonstrate that you've cleansed the you know, you've cleansed the potential or apparent conflict that might be there, right? So that's what you need to stamp onto your minutes for later on if somebody comes back to attack it. But
I think the rule is that there should be a written record of who was in that meeting in addition to the shareholders.
right,
You
right.
want a record of who was there, so you know who heard what.
Yeah, and look, I see it a lot on in nonprofit boards, you know, very capable people, very sophisticated folks, but when it comes to some of this stuff, they're like, well, why do we need that? And then you really have to explain, you know, you need this to protect your and justify your actions. Make sure you have, I mean, if you've spent the time and energy to do certain things, they should be reflected there, because that'll be the thing that helps you later on. So I want to spend the last 10 or so minutes.
9 minutes. I have a 3 o'clock conference call. I'm
Yeah,
sorry.
9 minutes, right? On talking a little bit about Sarbanes-Oxley. So, and why are we talking about it here? So, Odra, maybe you can give us a little bit of a discussion on why Sarbanes is important, and really its effect on compliance, and talking a little bit about who it applies to, who it doesn't apply to, what the misconceptions are. And then Alyssa, maybe you can talk about after that, talk about, you know, what kind of influence, even if it doesn't apply, which again, we'll find out. It's a little bit of a, you know, why is it so important? So, Odra, maybe you can start that off, and Alyssa can finish that up, and then we are at the end of our time when we do that.
Sure, sure. So, except for provisions that concern document destruction and whistleblower protection, uh, the governance provisions required by Sarbanes-Oxley generally apply only to public companies. But then there's a number of Sarbanes-Oxley provisions that affect both private and public companies, and violating them can result in severe penalties. For example, liabilities for violations of federal and state securities laws. These aren't dischargeable by bankruptcy. This includes liabilities for fraud in connection with private placement securities. There's also intentionally destroying, altering, or falsifying records or documents with the intention of impeding or influencing a federal agency investigation, or a federal agency or federal bankruptcy proceeding. So that's a crime punishable by fines and up to 20 years of imprisonment. And then retaliating against someone who provides law enforcement with truthful information relating to a potential federal offense, and retaliating against that person is a crime punishable by up to 10 years imprisonment. Despite its limited application, Sarbanes-Oxley has significantly impacted corporate compliance beyond just public companies, because many entities are voluntarily incorporating SOX principles into their own governance. I think that's perhaps with an eye towards what happens if they go public and trying to reverse engineer some of these compliance requirements.
Yeah, and look, quite honestly, financing money likes some of the compliance here. So even if you're not a public company yet, as you said, you're thinking about it. Maybe you're even thinking about it down the road. It's appealing to sources of financing if you have some of these structures in place. Whether that's warranted or not, I that's beyond what we're going to discuss here. But it is certainly something that people tick off on a box. So Alyssa, talk a little bit about why, aside from capital and things of that nature, what is it that would be useful in adopting some of these requirements if it doesn't apply to you?
Personally, I believe this action, what they're trying to do is statutorily mandate good behavior. And the truth of the matter is, if you're a private company and you do things properly, by keeping good records, by informing and having a relationship with your shareholders and following the rules that are supposed to dictate this company, and have evidence of that, you're not going to have a problem. However, people will say, well, I don't know if you're doing everything. I want to know that in writing you have all the requirements that big companies, the listed companies, adopt to make sure that your private company is going to act in the same manner. And that's overkill in a lot of situations, quite frankly, but it becomes the norm that what's done in large transactions or in widely offered securities that are subject to the listing rules. It's a little different when it's a handful of people in a small private company, and it becomes very expensive. And I note that even in large companies, I always use Enron as the example. We all know what happened there. And before it happened, they had been given an award for having a terrific corporate governance policy. So to adopt things that you're not going to follow or that aren't going to help here is somewhat silly. Whether or not it's useful in terms of saying the way we did things was in accordance with norms that have been adopted or have been stated in other contexts as being the good ones to follow, therefore we should be fine. I still say it depends on the circumstances. The relationship among a handful of stockholders in management versus one that's got 1,000 shareholders, or there's the issue of shareholder agreements and what interface they have. There's a lot of ways to comply and a lot of ways to consider all those issues and document it properly without adopting a federal statute that's designed for an entity operating within a different context. And I think Delaware, as distinct from things like the Sarbanes-Oxley Act, doesn't try to say, this is what you have to do in every situation. What they're trying to say is, depending upon the circumstances, was everything done properly, fairly, on an objective basis, in order to say things are being done properly. And no one set of rules is going to address every potential combination of circumstances or facts. So if you behave yourself and you do what you're supposed to do and abide by your fiduciary duties, whether you're in a corporate context or whatever your supposed duties are in an alternative entity, depending on what the agreements say, again, I say you're going to be fine. And I think relying on a set of standards that don't take into account the peculiarities of your particular entity and its relationships and its business is a mistake.
Yeah, and I think that some of the other conventional wisdom that would say says, hey, you adopt this because there are other, like as I mentioned, there's financing sources like it. They all seem to be people that are just trying to hedge risk, like auditors, a lot of external auditors.
Exactly.
Right? They've adopted it, so you have to kind of go with that sometimes. you know, people that are lending money, sometimes that, but again, it doesn't go to the heart of what
What
you're
they want.
saying.
No,
Exactly.
it doesn't do it. And I will tell you something. There are banks now, for example, you know, if somebody, the legal opinions from a Delaware lawyer with respect to compliance and enforceability and all that with respect to a loan, you know, the minimum loan was 20 million and up. You now see banks, because they have their checklist, the Sarbanes-Oxley triggered checklist, requiring them for loans of, you know, 2 million or 3 million. And I sit there going, seriously? Okay, I mean, it makes the cost of everything go up, which is why
Yeah.
when some say compliance becomes more expensive, you know, instead of spending the time worrying about whether you're adopting a set of procedures that work in another context, just spend the time doing things correctly.
Right.
And
Right. And
people
I think we can end off on that. We do also have a securities compliance episode of this webinar series. And we talk about in there, we do talk about SOX, and we talk about some of the legislative response to what Alyssa brought up in carving out some safe harbors for emerging businesses and businesses capitalized at certain levels. So it is not a hypothetical. It's an astute observation. Thank you, everybody, for a wonderful seminar again, and we'll look for you at the next part of this series.
Right, it was wonderful seeing both of you. I'm sorry we couldn't see our audience, but they should feel free to let us know if they need some more information.
And questions. Yep. All right. Thank you, guys. Take care.
Thank you. Bye-bye.
Thank you. Bye-bye.